Madam Speaker, MOM received about 9,000 salary-related claims involving some 4,500 employers in 2016. So 9,000 claims, 4,500 employers. Through mediation by MOM and adjudication by the Labour Court, we have been able to resolve more than 95% of these claims. The remaining 5% of the salary-related claims were unresolved because one of the employers has appealed to the Labour Court order, and the case is now with the High Court. 8 employers are still in business, but have yet to comply with their orders. While a vast majority, 199 out of 208 employers, had either ceased operation or faced impending business closure due to financial difficulties. So therefore, out of the 208 employers, 199 are either have closed down or are going to close down soon. So left with only 9 employers. 1 is appealing against our Labour Court order. 8 still have yet to comply with the order. All these companies have been debarred from hiring foreign workers until they comply with the Labour Court orders. The debarment also applies to culpable directors, even if they were to start new companies. We are also investigating those employers who are still in business because a non-payment of salary is an offence under the Employment Act. While it's not our intention to criminalize every non-payment of salary, especially if it's a result of business failure, we do prosecute serious or repeated cases for deterrence. In the last 3 years, 150 employers have been prosecuted and convicted for salary-related offences, and such offences carry a fine of between $3,000 and $15,000 per charge, or to imprisonment for a term not exceeding 6 months or both. Let me now turn to work injury cases. In 2016, over 99.9% of the approximately 16,000 injured workers had their cases successfully resolved, 99.9%. However, 5 out of these 16,000 cases did not, because their employers had failed to purchase work injury compensation insurance and were unable to pay due to financial difficulties. MOM take such offences seriously, and we prosecute such employers under the Work Injury Compensation Act and debars the companies and individual directors from hiring foreign workers until they compensate their workers. Such offences carry a maximum penalty of $10,000 or imprisonment of up to 12 months or both. In the last 5 years, 14 employers have been prosecuted for non-insurance and non-compensation of work injury. Madam, in most of the unresolved cases of unpaid salary, 5%, of unpaid salary, 5%, or work injury compensation, 0.01%, the chance of workers recovering payments from their employers is slim. This is not because the employers could just ignore and refuse to pay, but because they are mostly in deep financial difficulties, as I've explained earlier. For cases where there's still some hope of enforcing the orders for unpaid salary or work injury compensation, the workers are required to apply for the writ of seizure and sales through the state courts. This is the same process that applies to all unpaid civil court orders, including those made by the state courts. So in other words, the Labour Court orders is not less enforceable compared to those issued made by the state courts. All civil orders or all civil claims have to go through the same process. For those who need help, MOM assists the workers by advising them on the process and preparing the necessary documents. Eligible low-wage local workers may seek legal assistance from the Legal Aid Bureau, whereas foreign workers may approach the Migrant Workers Center. Workers can also apply to the State Court Registrar to waive or defer the cost of enforcing the order, or to recover this cost from the sales proceeds. Meanwhile, foreign workers with valid salary claims are also allowed to change employer. More than 2,200 of such requests were granted in the past 3 years. Madam Speaker, while we are relieved that the vast majority of unpaid salary, 95%, and work injury cases, 99.9%, are successfully resolved, we are, however, still concerned with workers who are unable to recover their claims because their employers no longer have the financial means to pay. We will continue to strengthen our support for them. Currently, foreign workers can already receive financial relief from the Migrant Workers Center. Likewise, for local low-wage workers, as announced in this House in August last year, those with unresolved salary claims will be able to receive short-term relief from the Tripartite Alliance for Dispute Management, TADEM, when it comes into operation in April this year. As for workers with more serious injury, if they fail to recover their work injury compensation and are in financial difficulties, we will continue to assist them through the Workers' Fund managed by the MOM. On the part of the workers, I urge them to bring their cases to MOM as early as possible. This will greatly improve the chances of successfully resolving their claims before the employers reach dire financial straits.